24901FH, People v. Terrence Woodruff. Terrence's plea.
Your Honor, Ron Haywood for the people.
Please, this honorable court, George Shedrow, P 41732, in behalf of Mr. Excuse me, Your Honor. Mr. Woodruff, we have no objection to doing this hearing by Zoom, Your Honor.
Mr. Woodruff, state your name for the record.
Terrence DeWitt Woodruff.
All right. Time and date set for a review in this case. Oh, I'm sorry, calendar conference in this case. Mr. Shedrow, there was a brief off the record conversation about you pursuing Mr. Simone to continue non-trial resolution negotiations. Is that correct?
That is correct, Your Honor.
All right, and Mr. Haywood, you said right now the government's position is a 1 to 5, plea with a 1 to 5
Yes, sir.
Department of Corrections sentence.
Yes, sir.
Okay. So, Mr. Shedrow, the court is going to allow you some additional time to continue those negotiations with the prosecution. You will have until July 26th.
Your Honor, that's a bad day. I started in-person jury trial. For a couple days.
So you will have until July 21st.
That's a good day.
That'll be at 9 a.m. Please keep the lines of communication open between the prosecution and defense. And bond conditions remain in place. Parties may disengage and continue with their day.
Thank you. Can Mr. Haygood, could you please email me that offer so I can talk to my client about it? And thank you. Bye, everybody.
Sure.
Judge, I have Mr. Perez in the waiting room.
Mr. Perez is not in the waiting room. There's nothing indicating the name Perez in the waiting room.
I told him to put his name in, Judge, and he said he did. So I'll have to text him too. Well, is there anybody in your waiting room? Because that might be him.
Popped up. He just popped up.
Okay, Judge, I'm ready on that if you are. Just give me another date.
No, hold on.
Okay. I just want to add, before I hit the road, I got to hit the road in a minute.
Elizondo. Okay, Mr. Harris.
No, you don't.
Now, are you on his other case, Lightfoot? Mr.
Yeah, I'm on
Harris.
I'm on Lightfoot and I'm on Perez, and I just contacted Perez. Should be in your waiting room. I don't know about Lightfoot. I can text him. He knew to get on. He had, he was given this date,
Okay.
but I'll text him to get on. He's the one that was complaining about me.
No,
So,
Judge
so-
Perez. We have the APA who's responsible for the Perez case present. I'm bringing in your client now. I'm also bringing in your other client now.
Oh, okay. Well, then I don't need to call him. Good.
Okay. Madam Clerk, you've given me the Perez file, and let's queue up the Lightfoot file. Calling 2100484501 FC, People v. Miguel Perez. Appearances, please.
Good morning, Your Honor. Ralph Elizondo, P41463 on behalf of the people.
Just good morning, Lau Harris, Mr. Perez is present. We consent to Zoom for today's hearing.
And Mr. Elizondo, Mr. Harris, is there a meeting of the minds as to what is going to happen next on this case?
Client wants to go to trial. It's a carjacking case. He hasn't indicated that, anything else other than that he wants to go to trial.
There is an offer, Judge. I can put that on the record.
Yes, please.
If for exchange for a plea to carjacking, people, let's see, count one, the people would dismiss all the remaining counts. The sentence agreement would be 2 to 20 on the carjacking. I'm sorry, and then also there would be a plea to the felony firearm that's associated with that. So that would be another 2 years. The guidelines on this case, Judge, we estimate are about 80 to 168. So our offer is well below.
And Mr. Harris, have you shared that offer with your client?
No, I think that 2 to 20 is a new offer, but perhaps you can put me in a breakout room for a second, Judge, and we can discuss it.
That's 2 to 20 plus a FF.
Right, 2 plus 2 to 20. So,
All right, I'm creating a breakout room for you to talk with your client. Mr. Perez, Mr. Harris, please follow the prompt to join breakout room. Popping up on your screens now. DOC, Ken Ross Correctional. Ms. Robinson, who is your client?
Good morning, Judge. I'm here for Nathaniel Johnson. He is going to be zooming in from Quality Behavioral Health.
That's what the Ellis case, Ms. Knapp is on it. Who is the prosecutor on that case?
Ms. Knapp, Mr. Haywood's directing a question at you. Can you hear him?
So sorry. No, I didn't. I'm sorry.
Ms. Knapp, what's Mr. Ellis charged with? Because I don't have that file. 'Cause it wasn't on my
He's charged with home invasion, GBH, felonious assault, and 2 counts of FF and a misdemeanor DV. I believe that, well, I can tell you Shelley Drain was the prosecutor at the PCC. Stephen Lockweiler was the prosecutor at the AOI. We then had a calendar conference and it was you and or Mr. or Ms. Daher.
Okay, so it'll be Ms. Dahar.
Okay, thank you.
Thank you.
Does anybody know where she is?
Mr. Perez, there's the prompt to join the breakout room. It was at the bottom of your screen. You should have hit it.
Judge, he's not joining the room, Mr. Perez.
See, I saw it. I'm gonna create that one more time.
All right, Mr. Perez, press the button that says join. I texted him to do that.
All right, Mr. Perez, Mr. Harris, follow the prompts to join breakout room 2.
He's texting me saying, I don't know how to do that. And my audio ain't working.
It's on the screen.
So I'll have to call him on the phone, Judge. I'll call him on the phone
All
and
right,
discuss it with him. Which means I'm gonna have to disengage because I can't do Zoom and the phone at the same time. So
Okay.
I will log back in.
I'm gonna put you both in the waiting room and then you can.
All right.
take necessary from there. Okay. APA King, what matter are you checking in on? Kenny said he was coming back. Yeah, I don't know. I know there's still some limits on the building and I'm not sure what those limits are. I need to find out. Okay, calling the 2100368801FH. Madam Clerk, don't you have the, look at that, you got the file. Everything better. People be Daryl Carson. Appearances, please.
Good morning, Your Honor. Ron Hayward for the people.
And good morning, Your Honor. Brian Gagnon, Neighborhood Defender Services, P64220. Introduce yourself, sir.
All right, good morning to all the parties involved. And this is a final conference. Is there a meeting of the minds between the party or what's to happen at this point?
I'll take this. We're getting close, sir. It's a gun board issue. I believe I have all the necessary information. Passed it along, and I'm working with a member of the board. I would say in a couple of weeks, I think we're gonna have what we're looking for.
Mr. Gagnon, this case has been dragging along since last year.
I won't tell
We
you.
waiting
you're
on
wrong, sir.
here.
I will not tell you you are wrong.
He should be, if that's the case, he should be already halfway done with his probation.
That's what we're looking for, sir. And next time we come in here, that's what we're hoping we're gonna have.
And he is have two.
That's it.
Would the court allow us an in-person date? And
So why was this one in? Actually, yes, I'm not even, yes, yes. Yes,
he's as good as phones as I am. How's that sound?
yes, that's a yes. It will be in. All right, so have you submitted the letter at this point?
I've been speaking. We have, Cullen, I have gone to the board, a member of the board. We've had a lot of cases together. I show the board member what they're looking for. They have it. We just keep crossing paths. And I'm confident that the next time we walk in here, we're gonna have an answer.
All right.
And I have it all in front of me, so I'm not waiting on this in any form or fashion. I don't think the member of the board is waiting either.
So August, July, no, we're doing this in July. July 26th.
Got it.
Please keep the lines of communication open between the prosecution and defense. Between now and 7/26/22, that can be in, I'm writing in person. And bond conditions remain in place. Parties may continue on with their day.
Thanks again, everyone. Thanks for getting over, Frank.
My stress level is like, I can feel it in my. Okay, APA King, what are you checking in on?
Hey, good morning, Judge. I have Michael Stokes up for a review on a homicide matter with Mr. Woodyard as defense.
Okay,
This is the back.
okay, Mr. Stokes is
That's the question.
in custody, but we're still waiting on Mr. Wood.
Okay, I think we're just looking for trial date on this one, Judge. So I'll be on. Let me know when you're ready.
All right, thank
Mr.
you.
King, do you know who's on Vincent Alice?
Vincent Ellis, I don't, but I can look it up and let the court know, let everybody know in chat. Just give me a few minutes. I'll look it up and put it in chat.
Thank you. So when Mr. Haywood, when that pops up, I can relay the information. And Mr. Giroux, do you have that updated form now?
I do not believe so, Your Honor. Let me double check my email. I've been looking for it. Actually, it just came through. I will get this over to Mr. Brown right away.
Okay, well, I'll just keep you in the, well, just put yourself on mute, handle your business, and then,
Thank you very much, Your Honor.
Okay, Mr. Harris. And Mr.
Hello, this is APA King. I was asked to look up who was on the Ellis matter. The Ellis matter is APA Erica Moses, but she is in a jury trial today.
Did you hear anything on that, Liz?
Ms. Knapp.
Yes, Your Honor. I heard Mr. King.
Okay, could you reappear with your client on Thursday of this week?
Let me check. I can't do it at 9 o'clock. I can tell you that, Your Honor. I could do it if maybe we did it at 11. I have 2 in-persons in Livonia and a Zoom in Redford. Okay, but I'm discussing this case with the judge.
Hey. Okay, how are you?
No, Friday's no good.
Oh, that's right. Friday's no good.
I'm hoping she'll, APA Moses will be out of trial by Thursday.
Might be.
Well, they'll be to deliberations and she'll have a little wiggle room with her time. Oh, we're just gonna go for it, Ms. Knapp. So if you need, what did you say, 10, 11?
11, if that's possible, please.
Yes, that is possible.
Thank you so much. Okay, we'll
And
zoom
Judge,
in at 11.
And you're putting that on 11 o'clock on Thursday, the 30th. I will notify Ms. Moses.
Thank you, Mr. King. What is the Ellis?
Yeah. Thank you, Mr. King, and thank you, Your Honor.
Thank you, everyone.
Hold on, let me memorialize it on the record first.
Okay.
I didn't give it to you yet.
No.
Yeah.
Well, I can just write it on. I can write it on the
Here.
sheet.
No,
Oh, okay.
that's good.
All right, calling the Ellis matter 2200294801FH. Appearances, please.
Yes, good morning. APA Larry King for the people, P78774, standing in for my colleague, the assigned prosecutor on this case, who is Erica Moses.
And good morning, Your Honor. Leslie Knapp appearing on behalf of the defendant, Vincent Ellis. Your Honor, we consent to a Zoom hearing.
Okay, thank you. Mr. Ellis, state your name, please.
My name Vincent Ellis.
Mr. Ellis. Okay, the court does have this identified as an arraignment on the information. Ms. Knapp, what is your position on that arraignment?
Your Honor, I believe that we did already get him arraigned, but we will waive the formal reading and stand mute once again. Oh, I'm sorry. I said that. We had the same problem at the AOI. There was no prosecutor available, so it had to be adjourned to June 1st. Then you had no court clerk. So you're right, it is an AOI. I apologize. We'll waive and stand mute.
All right, so the court will enter a not guilty plea on your client's behalf. And I do see some notes in here about adjournment on 6/1 because of connection issues. Okay, so matter will be, the court is gonna just set a pretrial for the 30th of this month, which is Monday is now gonna be Thursday. So that'll be 6/30/2022. For APA Moses to appear. Thank you for standing in. APA King.
Thank you, Your Honor. As I indicated off the record, Ms. Moses is in the jury trial this morning. I have notified her by email of the new date.
All right, that'll be at 11 a.m. Bond conditions will remain the same.
Thank you, Your Honor, and thank you, Mr. King. I appreciate it. Mr. Ellis, I will call you. You're all set now. You can go.
Okay, thank you.
Okay, Mr. Harris, have you?
Yeah, hello, Judge, I'm here.
Yes, you were able to discuss your offer with Mr. Perez?
I did, and I'm hoping he was able to hook his audio up, because, yeah, I told him what the offer was. I told him that the guidelines started at 80 months if he's convicted of the carjacking. And I'll let him, hopefully get on the audio. He did not indicate he wanted to take that offer to me.
All right, now calling 2100484501 FC, People v. Miguel Perez. Appearances, please.
Ralph Elizondo, Assistant Prosecutor from 41463.
And Judge, again, good morning. Lyle Harris for Mr. Perez, who hopefully is hooked up to Zoom.
Okay, I'm on here now. Can you guys hear me?
State your name, sir.
It's Miguel Perez Jr.
Okay. Mr. Harris, have you had time to discuss the offer with your client?
I have. I told him the offer was 2 for the gun plus 2 to 20 for the carjacking. If he wanted to take that, if he doesn't, we go to trial. You know, if he gets convicted, he could get more. I mean, I explained that to him.
So right now, the offer is that appears to be a minimum of 48 months. And if your client is unsuccessful at trial, the new minimum was at 80 months?
Correct. +2.
+2. So the minimum is 80 plus 20, no. Yeah, plus 24. Is that right? So that's 104. It's a minimum of 48 or a minimum of 104. Is your client looking through the offer with
I
that?
told Judge, I told him what Mr. Elizondo told me, which is 2 for the gun, followed by a 2 to 20 for the carjacking. And based on his computations, if he were convicted, the guidelines started 80 months after the 2 years, is what I told him.
So, Mr. Perez, to try and make this Mr. Perez, right now, the deal as presented is 48 months minimum. If you go to trial and successful, this conversation becomes irrelevant. But if you go to trial and are unsuccessful, the new minimum number of months is 104. Do you understand that?
Judge.
Yes, the court can hear you now, Mr. Perez. Maybe try to get a little closer to your Wi-Fi antenna.
My phones keep on kicking me out from the meeting.
All right, we can hear you now. Did you understand the question that's before you?
Judge, I got bad signal. I'm getting kicked out from the meeting.
Your signal is weak, Mr. Perez.
Yes, sir.
All right, it sounds like you can hear us now. Can you hear me clearly now, sir?
I got very weak signal, so that I keep on getting kicked out from court, from the meeting.
Mr. Harris,
Yes, Judge.
can you come in person on Thursday? And I'll have Mr. Perez
Sure.
in
Yeah.
person on Thursday.
Yes.
Mr. Elizondo, is your calendar permissible? This case that I called, this case is now being moved to in-person proceeding this Thursday, July 30th. No, June 30th at 9 a.m.
You guys can't make it next week?
No, sir. Do you
Judge,
understand the gravity of what you are facing? Actually, don't answer that question. Just explore that question with your attorney.
Pardon me?
This Thursday, 9 a.m., in-person proceedings. Zoom is failing us at this point in time.
I'll
You
call
want to
them.
come in this Thursday?
Please reinforce the time and date to your client, Mr. Harris. Bond conditions remain in place.
Yes, Judge, will do.
Thank you, Judge.
All right, Mr. Haywood, while we still connected with Mr. Harris, let's move to the Lightfoot case, please. On Lightfoot, it is 2100648101F8 and 2100648101F8. What is this two? 006481001F8 2100 Okay, Lightfoot. Okay, let's Lightfoot. Okay, 21. Then I have the 22. I don't have the 20.
No, 22.
Wait, do have two 21s that are exactly the same case.
And that's okay. That's two different cases. 121.
do see someone put in for rent 22K. Do you have this file, Mr. Haywood?
Yes, I have both cases.
Okay, so this, yes, please. The one I said, have it says. Yeah, yes, please. Mr. Harris, are you still connected?
Yep.
All right, moving on to your Lightfoot. I'm gonna call the 22 case number on Lightfoot as well. That's 2200920001F8.
Yep.
All right, moving on to your Lightfoot. I'm gonna call the 22 case number on Lightfoot as well. That's Was this a reissue, Mr. Haywood?
No, they're, two separate cases. Your Honor.
No, I guess something's gotta be off here.
One took place on August 16th, 2018. The other one took place August 12th, 2021.
All right, something's amiss here now, but.
It was the same, they messed it up, they put the same thing, same information, because this one actually was supposed to be in here.
So, Mr. Haywood, the problem is that I have a information. Does one have an offense date in 2018?
Yes,
So I have both of
Oh,
them.
that's the 22.
that's the 22 case.
22 case has an offense date of 2018.
Correct.
I don't have there's a 22 case with an offense date of 2018.
Correct.
And then there's a 21 case with an offense date of what?
21.
21 case with a 21 offense date. I don't have a 21 case.
Oh, it's not in that sheet either. Do you have a copy of it? Attorney Haywood,
Copy of the, information.
for the 21 case?
Lightfoot case. Mr. Harris, returning to the record on the Lightfoot case, we've now clarified the information problem. So your client from 2021, there is an offense date of 2021, or let me recall these for the record. I'm really calling 21006480101 FH. Then I'm calling, really calling 22000920001 FH with a 2018 offense date. That's People v. Philip Lightfoot. Mr. Harris, your appearance. Mr. Haywood, your appearance.
Ron Hayward for the people vote cases.
Mr. Harris.
Yes, Judge, I was waiting for Mr. Haywood. Lyle Harris on behalf of Mr. Lightfoot on both files.
Okay, so one is a 2022 case number, or the 2021 case number is a CCW FIP with a HAB 4. Then the 2022 case number is a CCW FIP FF. Second offense notice and HAB 4. And Mr.
Judge,
Harris,
both felony firearms are felony firearm seconds.
well, you don't have 2 felony firearms. You only have the one. One information only contains CCW and possession by a felon unless it got amended at the exam.
Well, that's interesting, Judge, because my paperwork indicates felony firearm on both files, felon in possession, felony firearm on both files. Perhaps ask Mr. Hayward.
So, Mr. Harris, have you been supplied with an amended information as these cases have moved through the system?
Well, quite frankly, Judge, I'm on the road right now, and the last time I looked at the files, my understanding was, because I was at the exam when one was waived and one was held, that they were both waived over on felony firearm charges, and they're both felony firearm second because he has a felony firearm first. Now, if that's not correct, I'd like to hear that from Mr. Haywood.
What do you?
Because, well, the gun board made an offer, Judge, which Mr. Lightfoot knows about.
And what was that offer, Mr. Harris?
Well, the offer was, and again, my understanding is both files are felony firearm second. The offer was to dismiss both felony firearm second. We'll dismiss one case entirely with a felony firearm second and plead to the other case with a sentence agreement of 1 to 5 without the felony firearm. And that's a 1 to 5 either on the CCW or the felon in possession. Quite frankly, I don't have that right in front of me, but I know the offer essentially is 1 to 5 and drop both felony firearms. Both cases, both felony firearms of both cases.
That is the offer, but if that is the offer, are you taking that offer? Are you taking that offer, Mr. Harris?
I don't know whether Mr. Lightfoot wants to take the offer. He hasn't indicated to me that he does.
Okay.
All right, so
Hello?
So, Mr. Lightfoot, the court just heard you say hello, but before you say anything else, I think you might have another device in the background that's giving feedback. Or giving like a reverb. If you could mute that other device in the background, that would help your ability to communicate.
Can you hear me, Your Honor?
Yes, the court can hear you, Mr. Lightfoot. Mr. Lightfoot, just hear the offer that Mr. Haywood and Mr. Harris were speaking about.
Yes, I heard him.
Would you like to speak with Mr. Harris in a little more detail about that offer this morning? I can set you and him up with a breakout room.
No, Your Honor.
And is it your position that you would like to reject that offer?
Yes.
All right, well, Mr. Harris, there's nothing left to talk about at this point. We need to set trials on these.
Okay.
And,
Your Honor.
Mr. Lightfoot?
I had mentioned to you at the last court date that I need you to assign me counsel.
Is Mr. Harris retained counsel?
No.
All right, so he is your assigned attorney.
Well, I don't feel confident going to trial with him.
And why is that?
Because that's all he wanted me to do is take this cop, and the thing is, the charge was dismissed.
Well, sir, you have two independent charges against you. Do you understand that?
Yes, sir, Your Honor.
All right, hold on, Mr. Lightfoot. Mr. Harris, hold on. Ms. Robinson, calling your case next.
Okay, Judge, thank you.
Mr. Haywood, that's Nathaniel.
Johnson. Johnson.
Yes. Two 000056901 FC. People feed Nathaniel Johnson.
Judge, I don't know if the prosecutor put his appearance on, if so, I didn't hear, but Brandy Robinson from the Neighborhood Defender Service. My bar number is 66895, and I'm here on behalf of Nathaniel Johnson, who should be appearing by Zoom. He's in the waiting room, as I understand it.
No, he's not in the waiting room.
I was just.
Oh, he's there now. He just popped up.
Okay, thank you.
All right, is there a meeting of the minds between the parties on what's to happen next on this case?
Judge, no, I've been trying to get an offer in this case for several months now. I think there was an issue with APA Simone back in January. Mr. Haywood is the third prosecutor, kind of keep getting passed from one person to the next, but nobody's able to give me any guidance about an offer. And Mr. Johnson is very eager to resolve this matter. So we're ready when the people are, but we're just waiting to see what they
Mr.
want.
Simone, I believe, is still the supervising attorney for this particular courtroom. So I think you were right to mention his name then and now as being the one authority to propose any type of non-trial resolution to. Mr. Haywood, is there a file? Oh, I mean, an offer in the file today?
Yes, Your Honor.
Excellent. Mr. Simone?
Yes,
wrote
Your
it
Honor.
down.
There is a plea agreement, plea offer. Defendant plead guilty to count 1, robbery armed, and then we dismissed the habitual 4 with a sentence agreement of 10 to 30 years in the Michigan Department of Corrections.
10 years?
10 to 30 years in the Michigan Department of Corrections.
Yeah, so I think that's the old offer. And I want to make sure that Mr. Johnson can hear that. That is, I think the people put that offer in place at the first hearing, and we were shocked, frankly, because this is a case that did not involve an actual firearm. I think everybody understands that. I don't believe Mr. Johnson has any recent criminal history. There was no bloodshed. There was, I mean, it was a robbery. And so that's the whole purpose of my email communications. But 10 years is not an offer that he'd be willing to accept. And I think it's far above the guidelines, if I understand the guidelines to be correct. So we need to have some resolution on the counter proposal that I've been trying to get somebody to listen to. But that 10 years, I think, was what they put on the record the first time. And even for the record, Judge Hathaway was shocked by those numbers, given what he understood the facts to be as well. So we don't have a meeting of the minds if that is where they remain. I don't know if Mr. Simone has specifically reacted to any of the things that I brought up or been presented with those things. And I just for the record, I believe that his guidelines would be 21 to 70 months on the armed robbery. And I don't know if the people have a different view of what his priors are or what would count, but yeah, I don't know where 10 years is coming from.
Your Honor, you can set another date. Ms. Robinson, you can call Mr. Simone and talk to him about modification of the plea. He is here, so.
Mr. Haywood, did you see my email about it last week or no? Like, have you even talked that through with Mr. Simone directly? I'd like to know if he's heard this and is continuing to reject it, or if this is still going to be news to him.
I did not see your email.
Okay. So I'll resend my email and then I will try to reach out to APA Simone directly. But yeah, we've been trying to get some progress on this since January.
All right. (7/27/2022) 9 a.m. Moving that to a final, that'll be a final conference. All bond conditions remain in place. Parties may disengage and continue with their day.
Okay. Judge, could I just be put in a breakout room quickly with Mr. Johnson so that we can talk about what happened? He's at behavior, like a trend. He's at quality behavioral health, and it's hard for us to communicate outside of court.
Mr. Johnson, Attorney Robinson, follow the prompt to join breakout room 3 popping up on your screen now. All right, Madam Clerk, let's place a call to trial services to get Mr. Lightfoot, new attorney. Please.
He's the house attorney, right? Or no?
Yeah.
Just wanna make sure.
Attorney Humphrey, good morning.
Yes, sir. Good morning, Your Honor. Yes, sir.
Okay,
Yeah, my client is in the waiting room.
you're checking in on what case?
Mr. Carl Duhart, Your Honor. Sentencing.
Do we have that?
Wait, let me make sure.
Let's call him. And Mr. Haywood Duhart is here for sentencing. Have you had an opportunity to review the report?
It's just a CCW. Can I just get
1 year pro, absolutely. Make a Xerox of it if you would like. And Mr. Humphrey, you had the ability to review the report?
I did. I don't think I had a chance to necessarily go with client, but he understands the sentence agreement. We're ready to be forward with sentencing.
All right, Attorney Wyatt Harris, what matter are you checking in on?
Damon Alexander, Your Honor. Apparently, we don't have a pre-sentence report, and so we're going to need to get another date.
Are we failing in that regard, Ms. Williams?
Don't have it.
All right, on the Alexander case, I'll call that one while Mr. Haywood reviews the report on the other one. That would be 22000663001FH. People V. Damon Alexander, time and date set for sentencing in this case, appearances, please.
Got it right here for the people.
Good morning, Your Honor. Wyatt Harris, P54891 on behalf of Damon Alexander. Your Honor, Mr. Alexander, I believe is in your waiting room.
Scanning, I do see Alexander, yes.
Mr. Alexander, can you put on your video?
All right, Mr. Harris, you're gonna have to be burdened with communicating that with your client. Now, Mr. Harris, are you certain that your client submitted to the probation department for the drafting of the report?
No, I'm not, Your Honor. And I'm communicating with him now via text, but he's not answering.
His name is here. He is associated with at least one device.
Well, then might I suggest, Your Honor, just give us another date and do a re-referral.
Right. So we'll re-refer. New sentencing date of July 29. 7/29.
That works for me, Your Honor. Thank you.
9 a.m. Bond conditions remain in place. So have them call that probation phone number within 48 hours, Mr. Harris.
Okay.
All right, may disengage.
What day was it, Your Honor?
And
What day was it?
7/29.
7/29.
Thank you, Your Honor.
Morning, Dave. Mr. Harris, you got another case?
No, I do not, Your Honor.
All right, enjoy your day.
Yes, I am.
There's a special prosecutor on
No,
that?
Mr. Haywood, I gotta go. I'll be right back. But you know, I got it on Zoom too, if y'all let me in.
Yes, I see your name. I did just Zoom so janky this morning. We just wait. Okay.
So we're ready to do it.
Duhart.
Yes.
All right, Mr. Humphreys, returning to your case, looking for your client.
He's in the breakout room, Your Honor, he says.
Yes, pulling them in. Calling 2100150201 FH. People v. Mr. Carl Duhart, appearances, please.
I'm right here.
Joseph Humphrey, on behalf of Mr. Duhart.
Mr. Duhart, state your name, please.
Carl Duhart.
All right, time and date set for sentencing in this case. Mr. Humphreys, has the defense had an opportunity to review the pre-sentence report, and do you cite any?
I have
edits?
looked at it. No, there are not, and he's anticipating a probationary sentence. Would ask the court to follow that, and any you know, positive things added by the court. He is working, he is supporting the family. We're ready to go.
And Mr. Haywood, Mr. Humphreys, time served agreed upon at 3 days.
Well, no, it's about 8 days because he got caught up on a warrant, and I had to get him stayed in jail about another 4 or 5 days. So I would move that up to 8 days, Your Honor.
Wow, the cover sheet actually has it at 0.
Hello?
Yeah, the court is amending it to 8. Mr. Haywood, anything additional from the people?
I didn't object to 3 days. I'm not sure because it's like, I'm not sure about exactly how many days it was, but
Mr. Humphreys, well, how did you get your client out of, did you have to go, did his family post a bond for him and you had to tell him what to do?
No. I had to go to your alternate, Miss I can't think of the name right now, Your Honor. Your female alternate, Davidson, Robinson, or whatever. You weren't available. You were still in training.
You mean
Had-
another judge? Judge?
Yes, sir. Yes, sir.
Claiborne?
Yeah. Your alternate at that time, and I had to present a motion, get him out of jail.
All right, so there may be some additional days to get to Judge Williams Claiborne. All right, that makes a little more sense. So I amended to 8 days. I don't see how something come into play here. All right, anything additional, Mr.
no, Your Honor. Quick policy.
All right, the court is going to engage in a sentence as follows. This will be a 1-year height of probation, the gun has to be forfeited to the arresting agency. Mr. Duhart, here's the rules and regulations to govern your behavior over the next year. You must perform 40 hours of community service. You must complete a psychological evaluation if directed by the field agent. You must complete the handgun intervention program. Your probation agent will tell you where you need to go, what you need to do to maintain that. Mr. Duhart, where are you working now, sir?
I'm working at this job called the Oakwood Group.
And what exactly do you do there?
It's a pressing company, like working with metal.
Stamping out metal forms?
Yeah.
All right, sir, well, just take the steps necessary to maintain your employment. If things change, try to get another job. You must pay $68 in state costs. You must pay a crime victim assessment in the amount of $1,300. Whoa, what happened
We
here?
asked that to be amended, John, to Merciful. He does have 2 children, just had a baby.
No,
He is
that's
working.
long.
He is a
Mr.
young.
Humphries, that's long gone. That was a typo. That was a typo.
I ain't never heard
The
that.
way,
That's the court.
what was your statutory? I forgot, you wrote it down.
Yeah.
That form.
130.
130. So we clearly know that the decimal was put. So not $1,300, but $130.
Okay, thank you, Your Honor. I was just trying to do the best I could. That's
Monthly monitoring will be at $30 a month, elevated to $60 if electronic monitoring was required. Court costs amended from $1,300 to $600. And were you retained on this, Mr. Humphrey?
yes, I was.
The attorney's fees are being eliminated completely to make sure it has you identified. And I'm changing your identifier from appointed to retained on the cover sheet.
Thank you, Your Honor.
That is the order of the court, Mr. Duhart. This is a height of probation, so there will be no appeal rights for you in this case. Mr. Duhart, those are the rules and regulations to govern your behavior for the next 12 months. Height of the Homes Youthful Trainee Act or height of status is something that's extremely valuable, sir. Please take full advantage. To get HIDA, it means you're a young man, and as a young man, you don't need to start trying to navigate life with a felony on your record. All right, parties may disengage and continue on with their day.
Thank you so much, Your Honor. Good seeing you.
Thank you.
You're welcome. All right, Ms. Diallo, Mr. Haywood, you said is the prosecutor on your matter.
I think so.
And Ms. Longstreet, you're checking in on what case?
Judge, I'm back from Friday on this Ron Sanders matter. You gave him a bond, 5,010% with a tether. The jail still has him on remand status. His family has been trying to post bond all weekend.
All right, well, I'll have Madam Clerk check on something. Mr. Brown, what matter are you checking in on?
Good morning, Your Honor. There on the computer, there's a reset for Ted Anderson. So I don't know if it's a real date or.
Who? Ted Newsom?
Anderson.
Ted Anderson is set for final conference today. CSC, first degree.
It is actually set for that.
That's what I have indicated on my docket for today.
Okay, well, you know, the computer, there's some that are generated. I don't know how they're generated. So don't let me start, whatever. And so I'm coming downtown, so I'll be there very shortly. I believe he's in the waiting room.
You made bond on CSC one first.
Hello there, Ms. Diallo. How are you?
Mr. Giroux, have we had some success in getting that document back and forth?
Yes, I believe it is in the inbox of whoever it needed to go to. I had returned it to the email that sent it to me.
All right, Mr. Haywood, can you confirm that you have your copy of it?
I can, if I send it to my intern, send it to him, but he has to go check his email. Yeah.
Ah, the intern. You won't be an intern long.
My son's an intern, he be paid internship.
And could you forward that to Natalie?
Williams
NATA.
at 3C.
Yeah, Natalie.Williams.
I have to run up to my computer upstairs, Your Honor, to do that.
Yeah, so we'll revisit the court date now. All right, CCW case.
Yeah, but I sent a letter over in May, so maybe they haven't figured it out yet.
All right.
What month is it?
Any feedback?
Is it June?
May to June, that's enough time for turnaround.
There she is, I think.
Ms. Longstreet, Madam Clerk is confirmed that the paperwork was sent over Friday.
Is there any way I can get a copy emailed to me so I can sort this out? I'm putting my email in the chat. If that's okay.
Yes.
Okay, Ms. Williams, is there any way possible we can forward that?
I mean,
Is it acceptable to forward that to Ms. Longstreet, or is there some kind of rule?
Yeah.
All right, so Ms. Longstreet, you said you put in the chat, your text, your email. So K Longstreet at ndsdetroit.org. All right, it's been forwarded to you, Ms. Longstreet. Let us know, or at least confirm that you've received it. All right.
Need more time,
Are
Judge.
you ready to call the corn game or?
We're gonna need more time to get to the decision, and I'll call Frank. But I did submit the letter immediately. It's not too-
Calling 2100158501FH, People v. Free Corn Gay. Appearances.
Gonna run here for the people.
Judge, good morning to you and your staff. Lillian Diallo, P52046, on behalf of Ms. Corngay, who is present via Zoom technology with consent.
Ms. Corngay, state your name for the record, madam.
Free Cordigay.
All right, and. Okay, so it was a brief off the record conversation. Ms. Diallo, you
Yes.
said you submitted a gun letter in
May
May.
19th, May 19th.
May
2022.
19th.
I don't have a copy, but if you can send me a copy, I'll jot the file with the letter
Okay.
off.
All right. Parties will reconvene on this case on July 27th.
Thank you.
Good day for the people.
Yes.
Good day for the defense.
Yes, thank you.
Ms. Corngay at 7/27/2022, 9 a.m. Bond conditions remain in place. Parties may log off and
Thank
continue on with their day. Please keep the lines of communication open between prosecution and defense.
You should be right up in here, because I know I've harassed you before. You said .com, right? .com? Okay. Okay, bye, everybody. Everybody have a great day.
We ready on Jerome? I mean, Mr. Jerome, man.
Good job.
We're about to be out of match.
I'm great. Thank you.
Bringing in Mr. Brown now, Mr. Jerome.
Thank you, Judge.
Calling.
Sorry, sir.
No, I don't think I think I cut you short from even giving. Calling 2100628901FH, People v. Jonathan Brown.
Good morning, Your Honor. Miles Drew on behalf of Mr. Brown, P number 84554.
Gonna run here for the people.
All right, and Mr. Brown, state your name for the record.
Jonathan, can you please state your name for the record? I think you're muted.
Oh, I apologize. I didn't know I was muted. My name is Jonathan Brown.
Okay, the court does have before it a plea form executed. What's plea form was already? Oh, no. This is the one.
It's the same one now because it was, the original was back when the topic when it accepted, but
Right.
now it's a new day.
Thought there was something.
No, it's the same.
Yeah, right. All right.
Today's
All right, so plea to count 3, dismiss counts 1, 2, 4, and 5. Sentence agreement to 2 years probation with the first 30 days in the Wayne County Jail, 80 hours of community service, fines and costs.
Correct, Your Honor.
habitual for.
And the habitual status will be withdrawn. And that is the defense's understanding of the offer, and they would like to take advantage of that?
Yes, Your Honor.
Mr. Brown, do you promise to tell the truth under penalty of perjury in this case?
I do.
Do you understand you have the right to challenge any witness and any evidence that the government brings against you?
I do.
Do you understand you have the right, with the aid of subpoena, to bring your own witnesses and your own evidence to conduct your half of the trial?
I do.
Trial will be open to the public and you would have a court-appointed attorney if needed. You understand that?
I understand.
And if you were to have a trial, you could remain silent at that trial and not be penalized for that silence. You understand that?
I understand.
And if you wanted to testify, that would be your decision and your decision alone. Nobody could force you to testify. You understand that?
Yes.
Okay. And sir, are you currently on probation or parole?
I'm on probation.
And that is to who?
Detroit.
Judge Bill, Your Honor.
I didn't hear, he didn't pick up what he said.
Say that one more time, that Zoom broke up.
Oh, sorry, it's with Judge Bill, Your Honor.
Oh, that's Wayne County. All right, well, have you let probation know about this other case? Or this?
Yes.
Case? Communicated with, and you're an American citizen?
I am.
And sir, you would like to give up your right to be presumed innocence and your right to have a trial by a jury of your peers to take advantage of the deal on your case this morning?
Correct.
All right, parties are satisfied with the waiver. Mr. Haywood, the facts, please.
I'm gonna ask a couple more questions.
Sure.
Sir, you understand? You said that because of plead guilty, you do not have a right of appeal, but it would be by leave. You understand that, sir?
Mr. Brown.
Mr. Brown, could you hear him?
Say it again. I didn't hear him.
I'll do it. Mr. Brown, because you are taking a plea agreement, since you're taking the deal, there's no automatic right to an appeal. Like if you went to trial and lost, that appeal is automatic. But because you're taking a deal, you can request an appeal, but there's no guarantee that that request would be granted. You understand that, Mr. Brown?
I understand.
All right. And sir, did anyone promise you anything outside of what's been memorialized in writing?
No.
To take this deal?
No.
It's the prosecutor burden to prove you guilty beyond a reasonable doubt. You understand that? You don't have to do anything. You understand that?
I really can't hear you.
All right. So, and you do know that the government has to prove their case against you beyond a reasonable doubt. You understand that?
I understand.
And taking the deal, they don't have to prove anything anymore because you're now admitting to it because the deal has made it worthwhile for you to admit it.
I understand.
All
right, Mr. Brown, can you hear me now?
I can hear you.
All right.
I am prepared to voir dire my client if the court would prefer that, but whatever is easiest in the court's opinion.
Go ahead, counsel.
All right, Mr. Brown, On April 18th of 2021, were you in the area of 13038 Algonac Street in Detroit, Michigan?
I was.
And on that day, did you have a gun on you?
I did.
And was that weapon concealed?
It was
And how did you conceal it?
under my shirt.
So if I understand you correctly, you had your shirt covering the weapon, correct?
Correct.
Is the court and prosecution satisfied with that as a factual basis for the plea?
Yeah, stipulate that it's in Wayne County, we're satisfied.
And that was in Wayne County, correct, Mr. Brown?
Correct.
And Mr. Brown, you didn't have a, you're not a CPL holder, and you didn't have any right to possess and carry that weapon concealed like you were, did you?
That's correct.
Court is likewise satisfied. Matter will be set for sentencing on 7/29/2022. Bond conditions will remain in place. Mr. Brown, call this number within 48 hours.
Give me 1 second. Hold on, let me get a pen for you.
I can write it down for you, John, and send you a text.
Okay, that's fine.
Just communicate this with your client. 313-224-2600. That's the phone number to Circuit Court Probation. Please keep the lines of communication between the defense and probation open at all times. 7/29/2022 at 9 a.m. Mr. Brown, they're going to create a report, and that report will be reviewed at your sentencing date.
Will do.
All right, parties may disengage and continue with their day.
Thank you very much, Your Honor. I hope you and your staff have a great day, and thank you for your patience with me this morning.
Same to you.
Blount Harris is on the phone. He's trying to understand what's going on.
Tell him he's being removed. He's being removed.
Okay. And Kimmy is should be on there.
I have a Brandon Richard, a Philip Lightfoot, a Aaron Vincent, William Shaw, Clarence Cox.
Attorney Kimmy.
Oh, he was able to track down his client from the Department of Corrections?
No, he's coming back to tell us, well, they will. Evidently, he wasn't ready because we didn't know that he needed to be. So he needs to tell us where he at.
All right, so he's at Kinross now. And actually, he's been moved since the last time we appeared. So.
Okay.
Like I said, the wrong facility. All right, body cam. All right, he'll check that.
True.
All right, Miss O'Mara, who's your client? Mr. Moxie.
My client is, let's see, Brandon Richard.
I do see Brandon Richard is in the waiting room.
Thank you. Yeah, yeah. Okay. This one. Okay. Thank you.
Mr. Lightfoot.
Hello?
Mr. Lightfoot, yes.
Yes, I'm here.
Okay. Mr. Lightfoot, I'm going to introduce you to Mr. Moxie, who will now be your attorney. Mr. Moxie, take an opportunity to introduce yourself.
Very good. Hi, Mr. Lightfoot. We'll talk a little bit later. Let's just process this today, all right?
Yes.
All right, so Mr. Moxie and Mr. Lightfoot, you all need to exchange contact information, please.
We're going to breakout room?
Well, I'm here in person. You got a pen and paper? I'll give you my number.
Okay. We're going to breakout room?
Well, I'm here in person. You ready?
Yes, Your Honor.
313-910-2787. After 4 today.
Excuse me?
After 4 today.
Okay.
All right. On 2100. On 21. 21006-101 FH. All right. And on 22000920001 FH, there was a breakdown in the relationship between Mr. Harris and Mr. Lightfoot. Mr. Moxley has now stepped in as appointed counsel. All right, parties may disengage and continue with their day.
Thank you, Judge. Any next date on this?
Have a good day to y'all.
Date will be July. July, August.
Have a good day to y'all.
August 3rd. Thanks, Judge. Thank you, Judge.
You're welcome. Final conference.
I'll be right there.
All right, bond conditions remain in place. Parties may disengage and continue with their days.
We have it listed as, and we have, yeah, the silver, yeah. Oh, okay, got it. Yeah. Oh, okay, all right, thank you.
All right, let me see the brand. All right, calling the, oh no, nope, not. Ms. O'Meara? Ms. O'Meara? Ms. O'Meara?
Hello?
Yeah, Mr. Richard, the court can hear you. Good morning, and you are now checked in on your matter. We're waiting for your your attorney, Ms. O'Meara, who's checked in previously. We're just waiting for her to reconnect now.
Okay, thank you. Yeah, I had just texted her right before when you said I was in the waiting room, and then I had just texted her. She said she was on another Zoom too, so she was waiting for I guess my case to be called again.
Waiting for her. Who's standing with Mr. Clemens just popped up. Aaron Vincent. He's here. Oh, what's the story on Mr. Goodyear? Ted Anderson, he said was out of custody. Like, it's 2K. Mr. Wood, you're right there.
Hi. I've been actually, I'm doing a Zoom right out in the hall.
Okay, I think Mr. APA King. Actually, APA, and your client is in custody?
He was. I don't know if they brought him over. Today's just a review set for trial date.
So he's in the back? All right, I have him. Bring it. Hey, APA King, I think you were checking in on Stokes. Mr. Woodyard is just walking to the courtroom. Ms. O'Mara, are you there yet? Mr. King just said he'll be right back. All right, well, let's just skip to Adam Clinton. Oh, he's gone. Oh no, Mr. Clemens, he's still there. Mr. Clemens. Aaron Vincent, is that one of yours, Mr. Haywood?
Yes, I'm here on Vincent.
Is that one of yours, Mr. Haywood?
Yes, Chairman.
Oh, okay. No, we're not ready. I mean, Stokes. Oh, you're not ready on Stokes? No. Oh, no, the APA just stepped away. Okay.
Just put him in the back. Come over there, Judge.
Just put him on.
Okay, here. Have it. Go now.
All right, calling the Aaron Vincent matter. 19009887001F8. People v. Aaron Vincent.
Right here.
Good morning, Your Honor.
Good morning, Mr. Vincent. Mr. Clemens, your appearance.
Your Honor, good morning. My name is Adam Clements, appearing on behalf of Mr. Vincent, who is also present. Sir, will you state your name for the record, please?
Good morning, Your Honor. Aaron Benson.
All right, I see that this is a CCW case from 2019. Is there any meeting of the minds on what's to happen on this case next?
Judge, if I could have a 2-week adjournment to get with Mr. Haywood, I'll get the case either resolved or we'll set it for trial at that point. I was newly retained on the file, Your Honor. I haven't been on it long.
Do you know if you're gonna have to appeal to the gun board, Mr. Clemens?
I think I may have to, yes.
All right, that turnaround is going to need to be more than 2 weeks. (2019) cases. You all have till July 29th to work this out. Please have it done.
Thank you. Thank you, Your Honor. We'll get it done.
Clement, you need to,
Final conference. Go ahead.
speak to Mr. Simone.
He says, speak to Mr. Simone.
Yes.
Okay, very good. Thank you.
All right.
You can sign off,
remain
Mr.
in place,
Vincent.
parties disengage and continue on with their day. All right, Bobby King. Attorney Kenny. Attorney Kenny.
Yes, sir.
Are you, your client was a kid, so are you certain he's going to be there at Ken Ross for a predictable amount of time, or no?
I'm just guessing, Judge. He's been there for at least a month. They shouldn't change him.
What level is Ken Ross? Is that level 1, or is it all of them in there?
I think it's all of them.
So this was for a sentencing, correct?
Correct, yeah.
Okay, this is
Ken Ross, MDOC.
Ken Ross, MDOC.
So I'll send it to Ms. Bettis. I don't know how long it usually takes.
Go to July. No, you're gonna be the last case on July 28th. Actually, let's not send that to this.
You gonna hold it?
That's gonna be one of the first things she does when she gets here. So we will send her with Ms. Bettis for some little tutoring.
For sure. We've been talking about it.
We're supposed to start.
Next week.
We're starting next week.
Visual assistant. Help us arrive. All right, you check your calendar on that, Mr. King?
What date?
7/28.
Oh, in the morning.
Yes.
Yes, sir. Thank you.
7/28/2022, 9 a.m. Right on here, MDOC. Writ.
Or six.
Yeah.
Okay.
All right, Mr. King, enjoy your day.
You too. Thank you, Judge.
So when I go on the record
Hill.
that's why you were just talking to Mr. King about.
No, let me put that on the record. Right, that is here. All right, so on 2100363101FH, People v. James Hill, matter has been rescheduled. Mr. Kenny informed the court that Mr. Hill had been moved to Ken Ross Correctional since the last time he was here, so a new writ will be set up for the hearing on 7/28/22 with the writ going to Ken. And Ms. O'Meara, can you hear us?
Yes, Your Honor.
Okay. On the Brandon Richard file, calling the Brandon Richard file. Two 22001443001FH. People v. Brandon Richard.
Good morning, Your Honor. Ron Hayward for the people.
And good morning, Your Honor. Catherine O'Meara, P53823 on behalf of Brandon Richard.
Mr. Richard, state your name, please.
Brandon Richard.
Ms. O'Meara, Mr. Haywood, is there a meeting of the minds on what's to happen next on this case?
Your Honor, I did send an email and attachments to Frank Simone in this case, and I didn't hear back from him. I did happen across him in another Zoom today and sent him a chat message trying to get his attention. I don't know how else to reach him. Back in the old days, I'd go down there and go to his office and get his attention, but I can't do that unless I have another case up and I sneak up to the prosecutor's office now. I don't know if there's a better way to reach Mr. Simone.
No. That's the only thing I know is email, Ms. O'Meara. What,
Yeah, that I sent the email like on the 16th though, so.
you, what are you trying to accomplish?
Trying to get the minimal jail time. I know there's required jail time in this charge, but trying to get the minimal jail time plea agreement.
What was your offer, plea offer?
I don't believe there ever was a sentence agreement offer. This case had been before Judge Morrow, and then it got kind of lost in the fray. It was before Judge Hathaway for a second, but he didn't think he would be there to do the sentencing if he gave the Cobb's evaluation. He had initially said 6 months would have been his Cobb's evaluation, but he didn't want to do that because he wouldn't be able to sentence. So we waited for the new judge to come in. I don't even think we knew it was going to be Judge Blount at the time. And then now it was, suggested that we go to Frank Simone. And I've had a hard time reaching him with email and phone. And now chat today, but he didn't respond to the chat. I don't know if he saw that I put it in there.
See if he has seen any of the information. See what the plea offer is. I don't know what the offer is. See how far apart we are with what.
All right, so Ms. O'Meara, I'm going to suggest that you send a new email to Mr. Simone and CC Mr. Haywood on that. Does that sound?
Sure, I can I'll just like re-forward it to Frank Simone and to Mr. Haywood as well.
All right. So bond conditions are going to remain in place on this case. The matter will be set for August 4th.
That'd be at 8:30 or at 9.
That'll be at 9 a.m. Actually, that'll be set for August 3rd. Strike that, August 3rd. Is that still a good day for the defense?
It'll be fine, Judge. If it's on Zoom, I have a matter. Either day will be fine, Your Honor. Just as long as it's on Zoom, I can be zoomed down from 36th District Court or from Macomb Circuit Court and do it there.
8/3/2022 at 9 a.m. Parties may disengage and continue with their day.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
8/4 or 8/22?
8-3. Attorney Kraus. Jari, what matter to check in on?
Yes, Clarence Collins.
Yes, Mr. Collins is in the waiting room. Mr. Haywood, is the Clarence Collins case one of yours? Excellent. Is there a resolution on that case?
We did have a plea offer, I believe there's architecture cost evaluation from council.
Yes, I did submit a Cobb's evaluation, Judge.
What email address did you submit that to?
Judge, I e-filed it and I sent it to Lynn Wade, who from my understanding was your JA currently.
No.
I got a copy.
Could you make a Xerox of that for me, please, Mr. Ingram? You. have the Clarence Collins?
Do not. I'll print,
The information.
yeah.
All right, Mr. Wood, your APA King is shown back up.
There we go.
Some progress here. Right, so you want to bring him to the
Yeah.
box, and because we're gonna do this Collins first, and then we'll do the Stokes.
Oh, okay, okay.
Oh, no, hold on, Mr. Stokes, you already in the box.
Right,
Okay,
right.
All right, hold on.
Yeah.
All right. All right, calling the calling the 21008390101FH. People be Clarence Collins. Appearances, please.
Your Honor, Ron Hayward for the people.
And good morning, Your Honor. Sarah Kraus-Jari, P81830, appearing on behalf of Clarence Collins. I am standing in for the attorney of record, Gabi Silver. Mr. Collins, can you unmute yourself and turn your camera on and state your name for the court?
Mr. Collins, your name, please.
Judge, if you want to pass, I'll try to give him a call.
No. Your client is definitely connected. I don't have any questions for him yet. Okay, so you're asking the court for a Cobb's evaluation on this case, correct?
That's correct, Your Honor.
And Mr. Haywood, what is the people's current offer at this point in time?
The offer that, last offer that was on the file was to defendant plead guilty as charged to O.W. White third. The sentence agreement of 2 years probation with the first 30 days in the Wayne County Jail, 80 hours of community service, drug and alcohol treatment and evaluation. That was it, Your Honor. And of course,
And Judge, that's actually my first time hearing that offer. Last,
That made me reread your call. I thought you said something about 1 to 5.
right. Last time we were present, the offer was 1 to 5.
And that might be correct, Your Honor, because I'm actually looking at the authorization and it's whited out. So this may be the new offer. I don't know if Ms. Cross or Ms. Silver has spoken to Mr. Simone and got a new offer, but that's the offer on the file.
Would you like a breakout room with your client?
If I could have one, Judge, that would be great.
All right, Mr. Collins, Attorney Kraus-Jari, follow the prompt to join breakout room 4. Yes. All right, in the waiting room. Let's call All right, so we're passing on the Collins matter. Let's call the Stokes matter. All right, APA King, Mr. Woodyard is now present.
Thank you. And I am back. I apologize. I had to go to Judge Williams Claiborne's court for a matter, but I am here now.
Okay, thank you. 2100283201FC. People v. Michael Stokes, appearances, please.
Good morning, Your Honor. APA Larry King for the people, P78774.
Judge Blount, good morning. To you, to your staff, good morning. Michael Woodyard. My P number is 64612. I'm here in the courtroom this morning on behalf of my client, Mr. Michael Stokes. He's also here. Mr. Stokes, say good morning. Will you please just say your name?
Good morning, Your Honor. My name is Michael Stokes.
All right, good morning to all the parties involved. The matter is set for a review date today. Is there a meeting of the minds on what's to happen next between the parties?
I believe everyone's in agreement, Your Honor, that this matter is headed towards a jury trial.
That is exactly correct, Your Honor. Hopefully we can set a date today. Not set today's date, but set the date for, you know.
All right. All right, so this is an in custody homicide in 2021. One count homicide, have 3 enhancement. And Mr. King, have the people made an offer in this case?
People did make an offer. The offer was to plead to second-degree homicide. The people would agree to withdraw the habitual offender notice, and there'd be a sentencing agreement to 25 to 40 years, Michigan Department of Corrections.
And Your Honor, Mr. Stokes has previously been apprised of that offer, and we have previously indicated on the record that he does not wish to take that, and that he wants to go to trial. Mr. Stokes, is that all, what I just said, is that all fair?
Yes, sir.
Okay, do you want to take a plea?
No, sir.
Okay.
All right, well, defense has made their position clear. How many witnesses for the prosecution?
4, potentially 5, Your Honor.
And how many for the defense?
2, Judge, including Mr. Stokes. And I will indicate, Your Honor, that Mr. King and I may very well be able to hammer out some stipulations based on whether my client, you know, what he and I talk about, but there may very well be some stipulations.
Okay, and there's no remaining motion practice on this case?
Nothing.
Not from the perspective of the people.
Okay. All right. Get a trial date here. Yeah, it's not looking good. Oh, Bobby, staring at the camera. I don't know why you're just staring at it. You said 5 for the people?
5 to 6, Your Honor.
That's still a short trial for a homicide, right?
I do believe, Judge, I think we can be completely finished with this case in 3 days at the moment.
I was just thinking 3 days myself, Your Honor.
Yeah.
Oh. You know what? I think we can get it September 15th.
Let's take a look. Your Honor, I already have a trial set that week. I would not be able to do that.
All right. Still on the record on the Stokes case. Of course, just gonna have to set another final conference.
Does the court have October dates available? Because that first week of October is a date where I don't have a trial.
No, unfortunately, that's not one of the weeks that my courtroom is allotted trials.
Judge, I was in front of another judge this morning who said they had been told that everything is opening up. So maybe that message is
So
coming.
that's why I'm
Maybe
waiting.
Let's
That's
set
why-
a new, yeah, let's set a new date then.
That's why I'm that's why I'm only gonna go out about a month,
Okay.
thinking we'll get greenlit on the rest of the year.
Word on the
And
street.
then Mr. Stokes can have his trial.
That's perfect, Judge.
Yeah,
That
stay in
I would
court.
appreciate.
I'm you know, kind of, you know, it's not the COVID numbers aren't really hard trending, like an accelerated trend downward. So it looks like it just doesn't want to go away. But actually, I'm going to go into August on this case. I'm going to adjourn the final conference into, no. I'm going into August, but I'm going to go deep into August. Let's do August, let's do August 24th.
That's fine.
That works for the people.
All right, 8/24/2022, 9 a.m. Bond conditions remain the same. All right, that concludes this matter. So I think we're gonna get released.
Thank you, Judge.
Open up.
Early release.
Release to do trial. Well done, Judge.
Yes, we're done.
Okay.
With this matter.
We'll make sure. Michael, you'll have to investigate.
All right. Matters remaining on the docket are William Shaver. Yeah, what was Catherine Woods? Oh, Shaver is the afternoon evidence. No, that's the county.
No, on the front, Ewing.
First page, right, first page. Work, all right, let's go from the front. Ted Anderson, Mr. Brown said he was on his way in person for that one. Clarence Collins, Ms. Jari is speaking to her client in a breakout room now on that one. And, oh, all right, okay, she's back. Ewing, the evidentiary hearing at Perkins' office was calling us about something. Michael Putman, oh, no, that's that post conviction.
Dauber.
And Shawver is a calendar conference. And Catherine Woods.
Did anyone show up for any of these? Do I need to call?
So no one has shown up on Catherine Woods. Well, let me see with the way. Mr. Shawver's here. And nobody has showed up on the Woods case. No one has shown up on the Putman case. Oh, no, that's the post conviction. No one has shown up on the. That's it. We're waiting on.
Okay.
Don't we have, don't we have another post conviction case on the docket for today from 2010?
You said, Putnam and Brown on the front page. Well, my front page. Putnam.
Oh, yeah,
Putnam.
Rashad Brown. That's not the one Mr. Harris appeared on. That was
He appeared
something
on
else.
Alexander. Sentencing on top.
Oh, okay, right. Wyatt Harris apparently was this person's attorney way back in 2010. All right, Ms. Kraus-Jari, what's the defense's position on that offer?
So, Judge, at this point, Mr. Collins is interested. He wants to check a few things over with his employer and discuss it with Ms. Silver. She's not here, and won't be for the rest of the week. So I'm gonna ask for a brief adjournment.
All right, 2100839101FH.
Gonna run it.
And Sarah Kraus, P81830 for Mr. Collins. I think he still might be stuck in the breakout room, Judge.
He's being dumped out right now. Mr. Collins, please state your name.
Clarence Collins Jr.
All right, and so there is a new offer on this case at this point in time. It is scheduled for a final conference. Court is going to offer a brief adjournment on that final conference to July.
Clarence Collins Jr.
July 29th.
That works for defense. Thank you.
Seven 2022 final conference, bond conditions remain in place. Please keep the lines of communication open between prosecution and defense. So if there's an offer to be put on the record on that date, see if the prosecution and defense can get the form executed before arrival that morning. That will prevent a lot of the mid-morning slowdown because we're emailing and scanning to each other.
Absolutely, Judge. Thank you.
All right, bond conditions remain in place. Parties may disengage and continue with their day. July 29th, 2022, 9 a.m. Okay, so we need to call attorneys on all remaining matters.
What's going on with Ewing is definitely taking this was a motion to at 1:30.
Yep, evidentiary hearing.
Okay, I thought you said somebody they were calling for something. Okay. It's still going on. don't see it on the docket.
I printed you a new one.
I know, I still don't see it. SHAW?
SHAWVER. Shaw Verber. Mrs. Simon, can you hear the court?
Yes, Judge.
Were you able to get a plea done on this case, Mr. Simon?
I don't believe so. There was an offer from the gun board, but Mr. Shavers indicated he wants to proceed to trial.
All right, set it for trial.
But is that still correct, Mr. Shaver? Is he present?
Yes, Mr. Shaver, yes, I'm in.
Okay, you're aware of the offer?
No.
Yeah, we went through this. Maybe the people can put the offer on the record.
With the same one?
2100623501FH. People v. William Shaver. Appearances, please.
Your Honor, Ron Hayward for the people.
Jonathan Simon on behalf of Mr. Shaver.
All right, and Mrs. Simon, you were looking for a trial date in this particular case?
That's correct, right, Mr. Shaver? You're not interested in the plea offer? The misdemeanor with a little, okay.
What was it?
Okay.
What was it again? It's the same one.
Mr. Haywood, could you please place the offer on the record?
No, I cannot recall it because I didn't know it was up today, so you're gonna have to tell them what the offer is. I don't recall.
Okay, yeah, just a minute, let me find it. I'm sure it's in my file. 1 second, please. It's not in my file. I do recall it was a misdemeanor with some jail time.
Thank you.
Okay.
Like I already served 3 months on GPS tether too, so.
Okay, well, tether time is not counted as time served.
Mr. Simon, you anticipate any motion practice from the defense on this case?
No, Your Honor.
All right. Final conference in this case will be September 7th. 8th is September 28th, 9 a.m. Final conference is also at 9 a.m. September 27th is the final conference trial date. September 28th, 9 a.m. All bond conditions remain in place. Parties may disengage and continue with their day.
Okay, September 27th, final conference, September 28th, trial.
September 7th is the final conference.
Oh,
September
that-
8th is trial.
September 7th, final conference. September 28th is trial. Gotcha. Okay, thank you.
All right, parties may disengage and continue with their day.
Thank you, Judge. Take care.
for a gun response.
Yeah, I don't know, Your Honor. I mean, obviously his charges, if he was convicted, would be in prison.
Yeah,
So,
he's gonna have to come back on the FA, right? This is a FA. What's up, Shaw?
Good morning, good afternoon, Your Honor.
Brandis, you know, pistol whip somebody. Yes, Mr. Upshaw, your client is not connected. You're checking in on Catherine Woods.
May I ask the court a question? Is this a review of a diversion, something of that nature?
Oh, this maybe it's from 2020. It might be. I hope it is. I hope they submitted a successful completion motion.
So that in March of 2021. So we haven't received anything. So he needs to reach out.
Have you received a discharge motion from Mr. Heathy, Mr. Upshaw? Because we haven't. We were hoping we had one.
Yeah, normally we do not receive those. They send them to the court, but they haven't been sending them to defense counsels late for a while.
Oh, and this person, according to their
March.
it should have been discharged in March.
Yeah. Let me see here. Okay, let me see.
So now we just waiting on Mr. We're just waiting on Mark Brown.
Sure. Yeah. Quick question. Is there a particular number?
And you're not on Ted Anderson, are you, Mr.
No, I mean, like,
no,
See,
I don't know
first.
who's transferred.
that's all you have left?
Yeah. Mr. Brown, you said he's on his way down.
Yeah.
And I don't know who,
All right. No, okay.
none of your colleagues have checked in on this matter either.
So, he does that, right?
Yeah.
Do you have a number for Heathy or actually? Let's see if I can email. What's his first name?
William. Bill, William.
There it is.
Yeah. Yeah, I'm sorry, I don't have it. I'll be back at 1:30.
I put an email in to him, about that, and, we could just, you could just sign it and I enter it.
Yeah.
We don't have to, have it.
So, Mr. Upshaw, yeah, you can go ahead and disengage, sir. We're gonna treat that, like what you said, it being a diversion review for hopefully discharge. So we're just waiting for Mr. Heavey's office to get back with us, so we'll reach out to you if it's something other than what you think.
Okay, sir, and you have a good day. Thank you.
Yep, you too.
All right, that's it, so 1:30.
No, we're waiting on Mark Brown.
Now, I forgot, you did mention that. And you said that a while ago.
He came on Zoom and he was like, oh, CSC one. Oh, okay, I'm coming down there.
Oh.
This Ted Anderson?
Yes.
So post convictions, you don't put on the record like Putman, that doesn't go on the record.
No, I'm not putting those. Okay. We just
Not right now.
put them there as placeholders.
Gotcha, okay.
He's gonna change next week. Getting some coverage. Then something gotta happen, because I got a 1 p.m. I still have some leftover orientation things to do that I need to do at 1 p.m. So that, and let me see that, where's the file for the motion? Because that's not gonna go to 2. I think this orientation I have to do is
Oh, okay.
a whole hour long.
Gotcha.
Already adjourned once, priority. Well, just let me know if,
Okay. You said he was coming down physically?
he said he was on his way down.
All right.
APA Cox, your appearance, please.
Perfect. I can hear the court now. Good afternoon, Your Honor. Carly Cox on behalf of the people, P 81911.
Good afternoon, Your Honor. May it please the court. My name is Mark Brown. My P number is 39562. Here on behalf of Mr. Ted Anderson, who's present via Zoom. Mr. Anderson, unmute your mic for a moment. Let the court know your name.
Ted M. Anderson.
Okay, APA Cox, Attorney Brown. Is there a meeting of the minds or what's to happen next on this case?
I don't believe so, Your Honor. I think that the offer still stands from previous conversations.
Why has the defense not availed themselves of the offer?
Well, I don't think it's with the, we've had conversations, so we're not willing to accept that offer at this point in time. Is Mr. Wheels still the supervisor of the case, Ms. Cox? Is Mr. Wheel the supervisor still in the case?
Yes. Yes. Sorry, Mr. Brown.
No, I'm sorry. Then I will have to see if I can have some conversations with her, which I've not had. So I'd like an opportunity to do that.
Okay, so this is an out of custody capital offender. They're going to be given a case from last year. Priority for trial. And what's the offer, Madam Prosecutor?
Your Honor, I believe it'd be for the defendant to plead guilty to one count of criminal sexual conduct in the first degree. The people would agree to dismiss all remaining counts and withdraw the habitual offender second offense notice with a sentence agreement of 25 to 40 years in the Michigan Department of Corrections, compliance with lifetime SORA Tier 3 registration and requirements. That would include lifetime electronic monitoring, completion of sex offender counseling and treatment, and no contact with the complainant in this case.
Mr. Brown, you have a little more than 1 month to get whatever deal you're gonna get. Improved, unimproved, whatever, but this case is gonna be treated. When you return, this case is gonna be treated as a priority and going to trial. Oh. Eight 5/2022. at 9 a.m. We got to August 5th to work this case out.
Thank you, Your Honor.
Bond conditions remain in place. Parties may disengage and continue with their day.
Thank you, Judge.
Thank you, Your Honor, and I apologize for not having this date on my calendar.
No problem. Enjoy your
Thank
day.
you, Your Honor.
You're welcome. Yes, all right, Mr. Perkins, Mr. Haywood. What's going on with this motion?
I'm sorry, I didn't hear you.
You all ready to be heard on this motion?
I am.
Give a recap of your pleadings.
And a sort of opening statement.
You want,
Sure.
you want to call it?
Yep. Put that sticker on the inside of the file. Right there. All right.
Oh, yeah.
This is 2100883501 FH. People v. Brandon Ewing. Appearances, please.
Good afternoon, Your Honor. Ron Haywood for the people.
Good afternoon, Your Honor. Good afternoon to your staff. May it please this honorable court. My name is Thomas Perkins, P 55623, appearing on behalf of Mr. Ewing, who's present. I would ask to allow him to appear by way of his own, Your Honor.
All right, let's proceed with your client on Zoom. And your pleadings.
Oh, pleadings. So, Your Honor, Mr. Haywood was ready to proceed last time. I think, well, does it record here too, Your Honor? Or do you?
Oh, yeah. And I don't think so.
May it please the court. Mr. Haywood was ready to proceed last time with motion to quash, which we could have done, and I think the court just moved this over and subsumed it all into the motion to quash and the motion to suppress. What we have here, and I'll be very forthright. If you look at and I have the video here, but even beyond the video, Your Honor, what I anticipate the court hearing from, I believe it is Officer Zachary Simons. Zachary Simons will tell you, and I believe that he would not change his testimony from what's found on page 15 of the preliminary examination transcript. Now, and I'll cite that and reference that for my opening, and then give the court, ask the court for direction as to how we proceed. But I've directed page 15, line 11, question. Well, I may start at number 7, line 7, question, those two questions right there. Your Honor. Question, you said that you saw an individual, you saw this individual walking down the street, and you clearly saw a weapon in the person's back pocket, is that correct? Answer, yells. I'm assuming that would be yes. But nonetheless, it says yells.
Right, I see that.
Yes.
I'm sorry, how is that spelled?
Yes, YELLS. Oh, sorry about that. All right. Line 11, question. Okay, and you would agree that as you saw this weapon, it was unobstructed from any particular view or anything like that. You saw it, and which brought your attention to it and ultimately caused you to tell your partner to navigate the vehicle a certain way. Is that fair? Answer, yes. That's the substance of what the motion is about. What the court will see from the video is that Mr. Ewing was approached in a party store thereafter. He was questioned, he answered those questions, and in the process of answering those questions, the weapon was removed from him without incident.
He was placed in handcuffs without incident and then placed under arrest. And then the investigation began thereafter. So it's our argument that it violated his constitutional rights at that point because we have an open carry statute. If they were to conduct an investigation, perhaps if they detained him, but he wasn't detained, he was placed under arrest. He's placed in handcuffs. He's taken out of that store. So to the extent that it requires testimony of the officer or, you know, if we're, that's it. That's the whole case, Your Honor. The whole aspect of the constitutionality associated with this case. And the claims of the breaches of the Fourth Amendment. Because the conducted search thereafter would be fruit of the poisonous tree. I would allow the court to tell us how you would like us to go.
To conduct the search thereafter or to conduct the interrogation?
No, I'm saying they're free. They were asking him questions. Mr. Ewing was answering his question. And upon him answering two questions, he says on the video, he says, and I'm paraphrasing, I'll go back to the case. So he's asked two questions by, I believe, Simons, Officer Simons. And for the record, Simons is Symanns. Zachary, common spelling, Zachary. Asked him two questions. He says, is that gun registered to you? He says, no. He says, do you have a CPL? He says, no. And that thereafter, he reaches in the pocket. He reaches right. It's clearly on the body cam. You see it, it's a weapon. He takes it out of his back pocket, places it in handcuffs, and then they take him to the car. Then they make further investigation. Then they find out who he is. Then they find out he has a felony record. And then they charge him with the CCW, or it's clearly not CCW, but then they charge him with FIP and felony possession and felony firearm. But again, they breached. He wasn't, I mean, to the extent they wanted to ask him some more questions, they could have, but they didn't have a right to go on his person, to put him in handcuffs at that point. They knew nothing about him. And so to do otherwise is, it's a violation. And, you know, and some people will say, well, it's inevitable discovery. You know, the process by which we discover things is still important, because if he decided not to answer their questions, which he could, if he's entitled to do, if he's open carry, then there would be nothing, there would be nothing for them to do at that point. They continue watching him, maybe ask somebody what his name is, they can conduct their investigation that they want. But that's it. Thank you.
Mr. Haywood, any statement?
I believe that Mr. Perkins is changing the facts to meet what his argument is going to be. And I guess we'll see it on the tape. There's a tape here, we can see it. When you're talking about concealment, it doesn't have to be necessarily completely concealed. That's one of the reasons why officers or others were able to see it, because the person is doing a bad job of concealing the weapon. Or, as you probably, I don't know if you know, but having carried a gun before, sometimes you have it concealed, you think it's concealed, and it isn't. Depending on your clothing, depending on how you're moving, you know, your intent was to conceal it, but it really isn't concealed so somebody see it. So what is the intent of the person? I think that's very important. And in this case, the officer saw the gun in a back pocket. The gun is not in a holster outside of all of your clothing, where it's obviously, I am open carrying this weapon. And obviously, I want everybody to know that I'm carrying this weapon for open carry, not this case. A case where a person had a gun in the back pocket, which was concealed, but the officer was able to see the gun because the handle of the gun was sticking. And they go up and they talk to the defendant and ask him about it, and he tells them, ask him about, do you have a license? I don't have a license for it. The gun, where now you're carrying a concealed weapon, you don't have a license for it. All right, at that point, criminal activity is afoot. Terry comes into operation, comes into play, as well as probable cause announced to stop, detain, because you got somebody who is carrying a weapon without a license. And I believe that when the court hears all the evidence, I think the court's going to believe that is going to find that the judge over across the street, 36th District Magistrate, did not abuse of discretion, because you're seeing somebody, the officer is seeing somebody who's potentially carrying a loaded gun or some type of weapon, and they do not have a law, they do not have a legal basis to carry a weapon concealed, and they went up to ask him about this concealment. So I would ask the court to hear the information and then make the determination at that point. We will stand on our pleadings that were made by my co-counsel. And so we're ready to proceed.
Can I respond and maybe short some of this? And I appreciate the court asking for openings. I appreciate the court asking for openings. It does really guide the court. What you're also going to hear from Officer Simons, this is not just, so he said, the prosecutor put it out there, it said, is this intent? If it's the intent of an individual, and you'll see, I'm one of the other computers that I was gonna upload.
Yeah, I saw you.
Okay.
What do you want to do? The screen share?
The screen share.
All right,
Yeah.
it'll be good to go.
All right, so, so then what we have is not only an officers, they're driving down the street to another radio run. So if it's the intent of Mr. Ewing to conceal this, they're driving down the street, he's walking into the store. It is so obvious that he has a firearm on him that they stop a radio run and make a U-turn and approach Mr. Ewing. So it's clear there was no intent to conceal this item. You're also going to see the item on the video too. But again, as it relates to intent, there was no intent to do this. Again, how Terry comes into play when they don't evidence any issue relative to him being, they don't have, they approached him. One of the things I can applaud the officers about, regardless of the breach of his Fourth Amendment constitutional right, but the professionalism that they did handle this with, they approached him as a citizen, as police officers. We would like to see them conduct themselves like this, just to know the law a little bit better. And I think that's where you come in
So, Mr. Perkins, are you saying that this was an open carry situation?
Clear.
Because of the way the officers were so able to easily see the weapon?
Yes.
So therefore, from a distance, from a patrol car, they can see open carry. Open carry immediately signals compliance with the law because it's not concealed. And therefore, there should have been no approach to even inquire, to lead to an inquiry to your client to then reveal that he was a felon, and it all falls apart from there for your client.
Somewhat. Where the court is correct is they're free to question him about anything. He's free not to answer. He answered their questions, and then they made the decision before they found out he was a felon. They didn't find out he was a felon until they took him to the scout car. He's already placed in the back seat, and then they run his name. That's when they found out, not in the store when they placed him under arrest. That's what I'm saying. And so that, so there was no Terry issue. If you would have seen a Terry issue, they'd have come in there with their guns drawn because Terry's about safety and security for the officers, right? They felt no insecurity when he's in a store amongst many other people and citizens of the community who he's in the store with. And that was what I was saying about how these officers did conduct themselves in the manner that they were. They were very professional. They were very cordial to him. They just broke the law, or they just broke his or disturbed and disrupted his constitutional, his protection against the Fourth Amendment violation that took place.
And Mr. Haywood, your position or the government's position, your colleague who did the pleading, is that there was at least some form of partial concealment that was cited by the officer.
Yeah, I mean,
and that becomes what predicates how this investigation plays out. That's the spark to the flame.
Yeah, sure.
All right.
I mean, and I can make another side argument, but I mean, what Mr. Perkins seems to be saying, that if somebody is obviously open carry, an officer cannot go and approach that person and ask them questions. I don't believe there's going to be any case law that I didn't read any in his brief that says that they can't do that. That is something illegal for an officer to come up and ask somebody a question. So, but that didn't happen here. They saw the gun. So let's go with what really happened. Ready to have that?
Yes.
And since Mr. Perkins started on that.
No, it's his burden. I made the Constitution, right? It becomes his burden. Because I can go home. If he doesn't want to substantiate his burden, then the court has nothing to do but accept.
I'm pretty sure he's going to attempt to substantiate his burden.
What he's trying to do is establish that I have to directly lead or direct this individual when I don't believe I have to.
Officer, just check in with the reporter, give me your full name.
SYMANS.
All right, officer, stand to be sworn. Officer, state your name.
Zachary Simmons.
And do you promise the testimony you're about to give is going to be truthful under the penalty of perjury?
Yes.
All right, you may be seated. Mr. Haywood, to take over the case.
Fine, Your Honor. I'm not sure why. Most of the time, if in this case, Mr. Perkins, the moving party, we just go and ask the questions. That's fine. Sir, take your full name for the record.
Zachary Simmons.
And Mr. Simmons, Officer Simmons, how long have you been an officer?
About 1 year.
I would take you back to the date of June 5th, 2021. You recall coming in contact with the person behind you on the screen?
Yes.
And where was that at?
I was at Kendall and Greenfield, at the liquor store.
City of Detroit?
Yes.
Who were you with?
My partner, Peter Reed.
And what drew your attention to the defendant?
Honestly, he had a gun in his back right pocket, see the handle poking out, the rest gun concealed in the back pocket.
When you first saw the defendant, where were you at?
So I was driving south down Greenfield, and he was walking into the liquor store.
And were you passenger or actually driver of the vehicle?
Passenger.
And are you in a scout car?
Yes.
Are you dressed similar to how you're dressed today?
Yes.
So you see the defendant, and you believe at the time you saw the defendant, he had a gun?
Yes.
Where was it exactly?
It was in his back right pocket.
And how much of the gun were you able to see?
I was able to see part of the handle. So,
And based on your experience as a police officer, you believe that to be a gun?
yes.
And what did you do at that point?
I informed my partner what I saw. We turned the scout car around, entered the liquor store, and I asked the defendant if he had a CPL.
So you saw the defendant go into the liquor store? Yes. And the store also?
Yes.
Both you and your partner?
Yes.
When you approached the defendant, where was he at?
He was standing by the counter.
And you approached him and did what?
I asked him if he had a CPL.
What did he tell you?
No.
Is it illegal in the state of Michigan for people to carry a concealed firearm without a concealed license permit?
Yes.
So once he told you that he did not have a license, what did you do next?
I asked him if the gun was his. And then after that, he replied no. I placed him in handcuffs.
Did you do that while you were in the store?
Yes.
How many people were in the store, if you recall?
Roughly 10.
And so you put him in handcuffs. Do you ask him any more questions in the store, or do you take him out of the store?
We took him out of the store.
Where did you take him to?
We placed him in the back of our scout car.
Did you ask him any questions on the way from the store to the scout car?
Not that I can recall.
And you placed him in the back of the scout car?
Yes.
What do you say? What happens after you place him in the back of the scout car?
At that point, he was mainly just concerned about his money. Wanted to provide proof of where he got it from. He thought we were gonna take it or forfeit his money.
He had money on him, or
He had roughly $10,000 on him.
$10,000?
Yes.
Where was that at?
I remember correctly, it was in his front pocket.
At some point, did you tell the defendant that you were gonna take him into custody based on having this gun?
Yeah.
What kind of gun was it?
On those like Glock 36 or 32.
Was it loaded?
Yes.
After you had removed the gun from the defendant and taken him outside and put him in the car, did you ask him anything else about why he had the gun or the circumstances of why he had that gun?
Nothing I can recall.
Yes, you may. Officer Simon, good afternoon. You testified in this matter before, have you not?
Yes.
And you believe that you testified consistently today than what you said before, is that fair?
Yes.
Okay. And you testified, would it be a correct statement that you testified when I asked you these questions that you gave these answers? And I'm drawing your attention to page 15 of your preliminary, you testified at a preliminary examination where I asked you some questions over at 36th District Court, did I not?
Yes.
And when I asked you those questions, you understood them at the time, or you would have said you didn't understand them, is that fair?
Yes.
And when I asked you this question, I'm going to line 7 of page 15, it says, question, you said you saw that individual, you saw this individual walking down the street, and you clearly saw a weapon in the person's back pocket, is that correct?
Yes.
And you answered yes, is that correct?
Yes.
Although the transcript says yells, you didn't say yells, you said yes, did you not?
Yes.
Okay, you would agree that's a mistake someone else made, not you or I, in my understanding and what you're vocalizing.
Yes.
Okay. You also indicated when I asked you that question, you said, okay. Or no, I said, okay. And you would agree that as you saw the weapon, it was unobstructed from any particular view or anything like that. You saw it and which brought your attention to it and ultimately caused you to tell your partner to navigate the vehicle a certain way. Is that fair?
Yes.
Answer yes. Is that correct?
Yes.
You would agree that when you approached Mr. Ewing in that store, you approached him and were asking him questions. Is that fair?
Yes.
You actually really only asked him 2 questions.
Yes.
You asked him, was the gun registered? I think to that extent,
Yes.
and he said no. And then you asked him, did he have a CPL? Is that correct?
Yes.
When he said he didn't have a CPL, you then saw, and your body cam, actually, you've seen your body cam, have you not?
Yes.
And your body cam shows that weapon it's plain as day coming out of that guy's pocket, right?
Yes.
And that's what, at the time when you saw it, you saw this individual walking down the street and you and your partner were on a radio run. Is that fair?
Yes.
To some other location, but when you saw that, or I'm not sure if your partner saw, but when you saw it, you told your partner, turn the vehicle around and let's go investigate this. Is that fair?
Yes.
And when you asked Mr. Ewing questions, he responded to them, did he not?
Yes.
And you, in fact, when you approached Mr. Ewing, you didn't have your guns drawn or anything like that. Is that fair?
Yes.
And when you found yourself to be fairly courteous to Mr. Ewing. Is that fair? It's about that money. Is that correct?
Yes.
You know officers who are similarly employed like yourself who might have forfeited that money.
That's irrelevant.
I withdraw it. But what I'm saying is you had an otherwise professional dialogue with Mr. Ewing. Is that fair?
Yes.
You had a person who responded questions that you asked him. Is that correct?
Yes.
You would agree that it was only after he was placed in that scout car that you ran his name that you recognized, I think at the station that you recognized that he had a felony record. Is that correct?
Yes.
All right. Oh, can I?
Yeah. Should be good to go.
Could you turn around for a second, Mr. Simon? Officer? Okay, does that appear to be your body cam?
Yes.
Okay, and I'm not here to trick you or anything like that. I'm gonna play it for a second so you can tell whether that is or not, okay? Does that appear to be your body cam?
Yes.
You're the person who initially approaches Mr. Hold on, you missed it as you turned around. Let me rewind it for a second. Somehow. So. How do I?
You gotta do Mr. Burton.
How am I gonna play the sound?
Oh, we had a problem with this once before.
Can I approach him with my laptop and then he can hear the sound at least?
Yeah, that's fine.
Okay.
Mr. Perkins, watch your stuff on the courts, please.
Yep, yep.
Playing it from the laptop.
You still going to screen share, so right?
Oh, I'm gonna keep that up there, but I'm gonna stop talking and then it'll hopefully not reverberate. Okay, that was you, was that you and was that you, that was your voice, is that correct?
Yes.
That was you that approached and ultimately removed that weapon from Mr. Ewing, is that correct?
Yes.
And all this happened before you were able to determine whether or not he had a felony record, correct?
Yes.
Oh. Going back, you said that you were on a radio run, you were actually traveling in the opposite direction of where you had to navigate in order to encounter Mr. Ewing, is that correct?
Yeah.
Okay, and even traveling in that kind of route, and in that, ultimately, in that circuitous fashion, if I may borrow that, you still recognize it was a firearm that he had on this person, is that?
Yes.
You believe it to be a firearm, is that correct?
Yes.
All right, I want to talk to you a little bit about the concealment of the weapon. So the defendant is wearing.
That would delete. Waiting to send that question.
No,
overruled, overruled.
The defendant was wearing like a t-shirt, if you will.
Yes.
Is that correct?
Yes.
All right. And so when you first saw him outside, not so much inside, but outside, you said you saw you saw the handle of the gun.
So outside the liquor store, when he was walking in, the t-shirt was not covering the gun, so they have to see part of the handle.
But do you recall if the t-shirt was under the gun?
It was not. Just to my recollection.
But you were able to clearly see is what you believe to be a handgun or a handle of a handgun.
Yes.
At that time, would you say that the gun, what was the gun, how much was the gun covered? 25%, 50%, 30, or 40%?
70%.
And so, you ever seen anybody open carry before?
Yes.
Would you classify the defendant as open carry?
Objection, that's illegal. That's up to the court.
Sustained. So, officer, I'm gonna ask you some questions.
Yes.
Were you able to see Okay, from what you saw, did it appear that, and I'm talking about when you were in your patrol car, did it appear that the weapon was, the barrel was facing down inside the pocket, or was the barrel facing up?
Barrel was facing down.
So you were able to see essentially the top of the grip, or what would be the back of the grip if you were holding a handgun in a traditional fashion.
So it wasn't like an angle. What's up with that?
Right. Now, were you able to see as much as also to the rear of the slide of the gun?
No.
No. And were you able to see as much to expose the trigger guard?
No.
No. Were you able to see essentially, this is an automatic, right? Were you able to see where the clip, could you see that the bottom of the clip was,
Yeah.
well, I should say the
Magazine.
you could clearly, right, magazine, appropriate language. You could see that the magazine, there was a magazine that was in place at the bottom of the hand, or the bottom of the grip.
Well,
There wasn't a void there.
yeah.
Okay, so you can see that. All right, I have no further questions.
When you, at what point could you couldn't see that?
Well, I
Well,
could
at
see
what
the
point, at
magazine
what point
until I
did you
walked
see?
in.
I'm sorry, what the court just asked you, at what point were you able to see that?
So the magazine in the gun, I wouldn't be able to see until I walked into the liquor store, but the rest of it I could see from there.
But just from the vehicle, you could see in what you believe to be the handgun,
The
the
handgun.
handle of the handgun.
Yes.
Nothing further.
Man,
Go ahead.
Officer Simon, what you saw in the store is the same thing you saw on the road. You were just at a more proximate location when you were seeing it in the store. Is that fair?
Yeah.
Okay, nothing further.
There's no further
I
inquiry of this witness.
I would move for the admission of, at least this portion of the video for the purpose of this hearing.
Yeah, I have no objection to that.
So move, granted, admitted.
Mr. Perkins was reading to you, page 15, line 11. Okay, you would agree that as you saw the weapon, it was unobstructed from any particular view. When you say when you say that it was unobstructed, did you mean that the handle was unobstructed, or the gun was unobstructed?
I meant like, as in there's nothing between me and him, so that I could clearly see the handle of the firearm.
There's nothing blocking your view. So
Yes.
Okay. Nothing further, Your Honor.
Judge, excuse me, for the video being marked, needs to be identified as a defendant's exhibit number or a letter.
Defendant exhibit A.
Yeah.
Defendant exhibit A.
And for, if it helps, this is Officer Simon's, body worn camera.
You're receiving it, Judge.
Yes, received admitted.
And nothing further.
All right, officer, you may step down.
So we're gonna step on the floor, okay?
All right, parties have anything additional for the court rules?
I'm not sure if is the court going to rule also on the wash also? I would just reiterate my opening statement, Your Honor. In order for the court to find that the magistrate abuse of discretion, the court would have to find it. In order for the court to quash the information, the court would have to find abuse of discretion. Clearly, there's no abuse of discretion here. You have evidence that was presented on the record that the officers saw a gun. They believed to be a gun. They went and they investigated the gun. The defendant asked about the gun. The defendant said he didn't have a license, and so therefore he was arrested and arrested for a couple of for the charges. Now he wasn't charged with anything because obviously the officers don't charge the prosecutor charge. So he was arrested for having carrying a weapon without a license. So it's clearly there cannot be this discretion based on facts in this case. As far as the suppression is concerned, Your Honor, clearly from what we heard and from what the court has seen, this is not an open carry. There's no way in the world you can jump and get to a factual basis that is true that the defendant was openly carrying his gun, that his gun was for open carry. That gun was clearly concealed or partially concealed. The officers saw that as him concealing the weapon, which you're not allowed to do without a license. Then when they asked him, "Hey, what about this? What that gun you got? You got a permit for it? No. Is it, do you have a license for it? No." I mean, they have a right to go up and ask anybody question. Whether you were, even if he was completely open carry, they still go up and ask him, "Hey, have you got a license for that gun?" There's no law that says they can't walk up and ask you a question. So when we suppress evidence, when we spank the officer's hand, if you will, it's when they have done something wrong, when they violated the law, when they violated some type of constitutional provision. There's nothing in this case that says they did any of that. You walk into somebody you believe to have a gun, walking into a liquor store where citizens are, you can go and investigate that person and ask them questions. "Hey, what about that gun you carrying in there? Do you have a license for that gun?" And clearly when he says, "I don't have a license for the gun," then the officers know that that's a crime and they can arrest him. If they went in there and it wasn't a gun, then it wasn't a gun, then fine, then they can let him go on his own, on his merry way. But in this case, that didn't happen. He admitted that it was a gun. They saw it was a gun, and he admitted that it was a gun. A gun's a gun, and he was arrested for that, for having a gun, having it concealed. So there is no basis for the quash. There's no basis for the suppression. There is no Miranda violation because the defendant already told them in the store that he did not have a license for the gun, which means at that point they can arrest him. So there is no Miranda violation. So I would have support to not suppress the evidence and not to quash the evidence. Thank you.
Your Honor, I think the prosecution's made my case in his argument. One is that he's indicated that, well, how do we go from partial concealment to the fact of what his intent was in his opening? What was the intent? This clearly, if this cop officer is driving down the street, there's clearly no intent, and we can base that on the circumstances. We don't have any testimony from Mr. Young other than what you heard. That wasn't testimony, but you heard that as part of an exhibit. There's clearly no factual set of circumstances that, if for one case, for once, you have something, we're not talking about facts here. We're talking about interpretation. And clearly, when we talk about the interpretation, we have to take the totality of what transpired. These officers are obviously focused on another radio run, so much so that this thing is so obvious to them that it is a firearm, what he saw from the firearm was the same as what he saw when he was in the store, which was the clip, the handle, and the top portion of that gun. But again, when he saw it, he knew it was a gun. So what he's saying, if you listen to the prosecutor's argument, is if somebody has a holster that covers or conceals that weapon, he himself said it wasn't like he had a holster. Why can't the back pocket be an ad hoc holster? So he's essentially wants the court to make a determination that you can't carry it any other way than either in a holster. So now he wants to dictate how open carry should take place. What is the intent? But he started out and said, what is the intent? There's clearly no intent by that individual. As you see that weapon, it's clearly protruding a large portion of it, 30%, 40% of that gun is coming out of that back pocket. It's clear that he had no intent in concealing it whatsoever. And then what happens thereafter, they are able to ask him questions. He was answering them. I'm afraid that Mr. Ewing might have continued answering questions anyway, but they never gave him the opportunity. They superimpose themselves on the situation. That's where the violation comes. That's where the court is being asked to act. And that's what we're asking the court to move to suppress the fruits of this poisonous tree. Thank you.
All right, well, gentlemen, thank you for your arguments. I've heard the arguments of the parties, the testimony of Officer Simon, and the one exhibit was admitted by defense counsel. So there is a issue here that essentially stems from the visual observations of a police officer. And they were able to observe a gun. Now the parties are trying to make a distinction between, it almost seems like the point and counterpoint is partial concealment equals a violation of the CCW law. And therefore that triggers an investigation and that triggers charges. The other side wants to say partial open carry does not trigger the CCW law. Well, and then whether there were continued violations of the law once the officers approached the defendant, Mr. Ewing, that included a Miranda violation. The court is not going to see in favor of the defense in this particular case. I do believe a majority of the statutes and case law in Michigan establish that partial concealment is enough to trigger an investigation and to substantiate a charge for the CCW violation in the state of Michigan. I am not familiar with any case law that essentially says partial open carry is not something that's permissible for investigation and arrest, but it's partial concealment. So I'm going to find that the jurists of the lower court did not abuse their discretion with that. Reflected in the transcript was pretty much mirrored here today, and that's what took place in the lower court. So I'm not going to find that the jurist of the lower court abused her discretion. I'm also not going to find cause to suppress, under Miranda, meaning that what sparked the initiation of the inquiry or investigation was purely visual observation. The minor questioning that was on camera before your client was taken into custody was simply, do you have the CPL? Is it registered? For the charges that are part of the information that are before the court today, there actually didn't need to be any continued interrogation. There didn't need to be any continued questioning for at least purpose of composing the information on the case. So at this point in time, I'm also going to not find in favor of the defense as far as the motion to suppress is concerned. Both matters are denied. That's the order of the court. Appreciate everybody's hard work.
May we have a date out approximately 3 weeks? I do have, I couldn't file my,
It's gonna be out further, Mr.
okay,
Perkins.
well, I think I can have something to Mr. Haywood early this week or early next week. I'm going on vacation.
But this matter will be pushed out to for a calendar conference on August August 9th. Eight, 9. Is that a good date?
Final conference.
Yes. 8/9/2022, 9 a.m. Bond conditions remain in place. Parties may disengage and continue with their day.
Thank you. My son.